Okay, so 5 units are there, and first 4 units are relating to torts. Fifth one, right? There we have two
Hmm.
different legislations. So that is like a separate part, but first 4 units. First one gives us an idea about torts. Remaining 3 units talks about different types of torts that may take place. Okay, so
Okay.
we have already discussed differences between tort and other different types of crimes. I will share those videos with you. And today we will begin with what tort actually is and what are the elements that we need to constitute tort. Okay, so you
Okay.
will
Okay.
see one topic also, development of tort law in India, how it has
Hmm.
developed, what tort is mainly. So when we
Okay.
talk about tort, it's derived from a Latin word called tortum, which means twisted, crooked, or what is not straight. So it
Hmm.
basically means that as we live in a society, right, there are certain set of behaviors that is expected out of us. Okay, and if we are not behaving in that certain way, we are doing something else that is nothing but twisted, crooked, or what is not straight. And that is what constitutes tort. All right,
Okay.
take for example, we live in a society. Okay, and you are not expected to enter someone else's private premises without their permission or without their invitation, right? We all know that we should not be entering someone else's private premises. But
Yes.
what if we enter there, right? In that case, what happens is it is nothing but we are behaving in a way which is not straight or which is not expected out of us, and that becomes a tort, the tort of trespass.
Okay.
Okay, so like that, we have different other types of torts also. Like you live in a society, maybe we both are neighbors. Okay, it is expected
Hmm.
that you do not play loud music at night and disturb your neighbor's sleep. But
Hmm.
what if you do? Maybe night 12 o'clock, you are playing loud music, and I want to sleep at that point in time, or maybe I want to work peacefully at that point in time. So, in such cases, what happens is it is nothing but something which was not expected out of you, but still you are doing it, and that is nothing but tort of nuisance. Okay, so this is what tort is that we see in day to day life around us. Okay, and there are different types of torts.
Hmm.
Okay, so tort is nothing but a civil wrong. So, what is a civil wrong? Civil wrong is like you must have heard criminal and civil. There are two classifications of law, right? When we talk about civil, it is little bit like a milder version. One person is affected, and there are so like in a civil court case would be fine. So, tort is nothing but a civil wrong. Like there are different types of torts: negligence, nuisance, trespass, etc., and these will affect private rights of individuals. If I'm entering your private premises without your permission or without your invitation, I'm affecting your private right, right? You have a
Yes.
right to live peacefully at your house, and I'm affecting that particular right. That is nothing but a tort. If you are playing loud music at night and disturbing my sleep, that means I also have a right to live peacefully in my house. You are disturbing them. That is nothing but nuisance. Like that, we have different types of torts. Okay, is this
Okay.
part clear?
Yes.
So you got an idea, right? What tort is? It's something that we see on a daily basis around us.
Got it.
Okay, then there are some definitions. I have added 4 very simple definitions in this document. I will be sharing this document with you, and there is no other option but to by heart the definitions. Okay, because we need to write it
Okay.
exactly how it is been defined, so you can remember it. Previously, 4 definitions are there. You can just see that.
Okay.
Okay, now coming to development of law of tort in India, how tort has developed. Like, have you seen any other legislation? Might be in your CA course, you had some law subjects as well, right?
Yes. Yes. I do have a lot of law-related subject. So
Contract,
the main core,
Unwritten
yes,
Law.
main core act which I practice daily is this Companies Act.
Companies Act, yeah. So when we talk about Companies Act, what is it? It's a legislation. Every single thing is written there, right? When you want to know whether it's there in Companies Act or not, what is the provision, you can simply open the bare act and you can read the provisions, right? It's that simple. But when we talk about torts, it's not like we have a legislation like Companies Act or Marine Act or something like that. We don't have a legislation. Okay, what happens is it has developed with time. Some people had some issues, some problems. They went to the court, case was filed, court tried to decide the matter. Like that, it has developed. Okay, we have a lot of cases, lot of different doctrines were developed in those cases. Like that, with time, it has developed. We don't have one single legislation where we will get all the provisions.
Okay.
So when we talk about law of torts, it is based on the principles of common law, which is primarily English law of tort. Like in England, what happens is judges get a lot of power in terms of interpretation or in terms of giving decisions. They are not bound to follow what is written in a certain legislation. They can apply their mind, they can give decisions, they can come up with new doctrines, etc. So that is what we call as common law. Okay, so from common law, English common law, it has developed, and judges, while trying to give decisions in different matters, while trying to interpret different provisions, they have eventually, like, this law of tort has developed. And we have also incorporated those provisions in us. We refer to those foreign cases also. And wherever needed, we made some changes as well. Like that, law of tort has come in India. So it is primarily derived from English law of torts. Whatever decisions were given there, whatever we felt relevant, we relied on those decisions. Okay.
Okay. So basically, it is unwritten law.
Yes, we can say it is unwritten law. But yes, in different decisions or in different judgments, you would see some provisions, some elements, some essentials being written. That is how it has developed. But it's not, you can say, yeah, it is not written, it is not codified in one single document. From multiple sources, it has come.
Okay.
Okay, so law of tort is selectively enforced in Indian courts if it suits the circumstances of Indian society. What is decided in England, it might not be that much relevant in India, right? So we would see if this is relevant or not. If it is relevant, we will apply it. Like that, we have seen even a certain concept is being applied in India, but with some changes. Okay, so like that, it will be selectively enforced. Whatever is relevant, how much ever it is relevant, that part will be applied in India.
Okay.
In India, the term tort has existed since pre-independence period. Tort did not have much of such an importance beginning under Hindu law and Muslim law compared to English law. Most of the laws of tort in India are adopted from English law of torts. In earlier times, what used to happen, right? For civil matters, for this different matters, right? People used to be governed by their own personal laws. After Britishers came, what they did is they formulated one same law for criminal matters, like one uniform law for criminal matters, that whether you are a Hindu, Muslim, Christian, irrespective of your religion, same law would be applicable to you in terms of criminal matters.
Okay.
But
what?
Yeah,
please go ahead.
But what happens is for civil matters, right? Most of the civil matters, they did not interfere there. That okay, fine. For civil matters, you will be governed by your own personal laws. Like there are some civil matters wherein we have a legislation, like property matters, rent dispute, we have legislation. But at the same time, there are other matters like divorce, child custody, inheritance, succession. All those matters would be governed by personal laws of the person. Like if you are a Hindu, Hindu law would be applicable. If you are a Muslim, Muslim law would be applicable. Christian, Christian law, like that, it applies. So when we talk about torts, because it is also a civil it also falls under civil classification. It has come from English law of torts. Whatever cases were decided, we tried to apply it based on applicability in Indian society. However, the Indian courts, before making any application of the laws adopted from the English law of tort, see whether it is compatible with Indian culture and circumstances or not, and it is having a distinctive application, not like simple copy paste, but we have tried to see some changes or make some changes. Like there is one concept in, I think, Unit 3, strict liability and absolute liability. So strict liability is a concept that was developed in England, and we tried to make some changes and we made it absolute liability with few changes. Same concept with few changes, and we applied that in India. Like that, it has come. Okay, in India, the origin of torts is related to Charter of 1726. So before independence, right, there were some charter acts, those used to provide for some rules and regulations that would apply. So origin of tort we have seen in Charter Act of 1726. So under this, the English courts were established in 3 presidencies, Bombay, Calcutta, Madras, which were known as mayor courts. And these were working under common law principles in India. Whatever were the process or workings in courts in England, that same process, that same procedure was followed, and these 3 courts were working under those principles. Okay, when we talk about common law principles, it is the principles that were followed in England, how courts should function, what kind of powers judges would be given, and all that.
Okay.
In the application of common law, the principle of equity, justice, and good conscience were being followed. So what is equity, justice, and good conscience? It is that you will not simply, just like a computer, you will not simply try to apply the law, what is written in a legislation. But what you try to do is, once a case is filed before you, you try to see, is it even making sense that we directly apply the legal principles there? Or do we need to make some changes? Okay, so we try to see what is just, what is fair, what is going to provide justice in this given situation. And based on that, we try to apply it. As in, judges get the, like option of applying their mind rather than simply following what is already written in a legislation. That is nothing but principles of equity, justice, and good conscience. Even now, these principles are being followed in certain situations wherein the written laws might not be providing justice. Okay, judges do have the option of applying their mind in such cases and giving a decision. Okay, and that's how the case laws become very much important for us. Okay, different doctrines, different concepts are also been provided there.
Okay.
Okay, law of torts was being considered as an inseparable part of the common law. Hello?
Ma'am,
Yeah,
I have joined right now.
Okay, so I'll share the recording. Okay, just one question we have started. Origin and development of tort law in India. I will share the recording. You can see the previous part also.
Okay, how many minutes, ma'am? Right now we have started.
In just 15 minutes, 7:15 we started.
Okay.
Yeah.
Okay.
So what happens is, from these principles are being applied. Law of tort was being considered as an inseparable part of common law. This was made applicable in India in this reference, but due care was taken that it is its application, conditions, customs, it suits Indian need, that was also given importance while applying these principles. So there was this case where it was stated that the rule of law of tort of England should be made applicable as per Indian atmosphere, that is corresponding to the traditions and customs of India. Now, what happens, right, when we talk about torts, it's something that we see in our day-to-day affairs also. So it's somehow related to the traditions and customs as well. Okay, so what will be followed? What is something that is acceptable in India? Something which might not be acceptable in India? Those things would also be taken into consideration. Okay, and after that only these principles would be applied, because laws vary a lot depending on the place also, right? So it has to satisfy, or it has to suit the needs of that particular society or those people. So it will be accordingly applied based on Indian situation. When we talk about development of law of torts in India, right, we have borrowed this concept from England. But if we look at the progress, it has seen a slow development in India. So what is the reason that we have a slow development, that some concepts were applied, for some we had no provisions, and with time few more concepts were added? Why was there a slow development in terms of law of torts in India? So it has originated from English law, and since 1726, law of tort has been made applicable in Indian courts, but the process was very slow. So 1726, under this charter, when these three courts were established, it was made applicable. But again, the progress was slow. And what are the reasons? First of all, that law is not codified. Like you said, it's not written somewhere. It's not written. So it took time, that with time, with different cases, it has come. Not like one single day a legislation was introduced and it became applicable. So that is one of the reasons why it has seen slow development, because there is always problem of uncertainty in front of the courts. Whenever a case comes before them, they don't have one single legislation to refer, but they have cases which are, like scattered everywhere. They need to see what is the principle, how it will be applied, what are the elements. Maybe one concept was developed in one case, in another case some elements were given, in another case some exceptions were given. Like that, it was all scattered.
Got it.
It is very difficult to decide which action comes under tort and which are not torts. The decision of courts are generally based on precedents. So what is precedent? Decisions given by court in previous cases, okay, which are very much important, which are landmark. We refer those decisions in all the upcoming cases. Okay, if today a case has come before the court and court said something, like recently there was this case, right, relating to hijab, wearing of hijab, it should be allowed or not. So if
Yes.
court has given a decision, court will invest their time, effort, energy, and give a decision. So it is said that if similar cases coming before you, that same decision you can follow. If that decision was not faulty or something, same decision you can follow in order to save time and in order to save efforts. That is nothing but concept of precedent. Okay, for torts also we follow precedents, that what was decided previously in a similar matter, same sort of a decision we can give. So this is one of the main reasons that law is not codified. We have multiple cases, multiple precedents that we need to refer, and from there it has the cases has to be decided. From there, concepts are being borrowed. Second is ignorance of law, that people are not aware of their legal rights. When we talk about torts, it is mainly violation of a legal right. A right has been given to you, that right to reside peacefully at your house. Might be you are not aware of that if somebody simply enters your house, that is trespass. In such a case, what happens, that you have a legal right, but you don't know that this kind of a right also exists, that nobody or a stranger cannot enter your house, even though he has not caused any loss, any harm. That simple entry of a stranger also is a violation of your legal right. Okay, so there is ignorance that these kind of rights also exist. Most people are illiterate and are unaware of their rights, and this is a reason why they do not move to the court for justice, even on violation of their rights. When people do not even realize that they have this kind of a right, there is no question of that person going to the court and filing a case for violation of that right. So that has also resulted in slow development. Next is poverty. Poverty has also contributed in slow development of torts. A number of people do not approach the court because, again, it would take a lot of time. It will take a lot of money for them to continue with the case. So what they do is they try to tolerate it up to a certain level. Because if we talk about torts, like I said, playing loud music at night, it is something which people would say that, okay, fine, let's tolerate rather than filing a case. So like that also it has contributed in slow development, that people are not going, their rights are not being, like they are not aware of their rights, and so different concepts has also not developed because that many cases are not going before the court. But now when we talk about these kind of matters, we have a concept called public interest litigation. These matters, right, poverty and all these things do not affect it that much in today's time because we have free legal aid being provided. We have a concept of public interest litigation, right? Maybe someone's right is being violated and that person is not going to the court, but someone else can file a case on that person's behalf. Public interest litigation, a litigation or a case filed for public interest, not for my personal interest. Nothing, I have not suffered any loss, but because somebody else has suffered, I am going to the court. So with development of these kind of concepts also, we have seen that there is progress. Plus there is free legal aid being provided under Article 39 of Constitution. So that has also helped people approach the court.
Ma'am, just to intervene you,
Yeah.
in such cases where public interest litigation is made, who will be the party for those cases?
Party, usually it is the person only who files the case, but along with him, other people, right, who are aggrieved, those people or their representative may also be added. Because usually it would be like maybe hundreds of people are being affected. And I'm going to the court and filing a case. It will be me versus whoever has caused the violation. Plus, court may try to add those victims also. But if there are hundreds of victims, it might be difficult to add all of them. Court might say that, okay, we are adding 5-6 representatives to represent those 100 people. 5-6 amongst them would be added. Like that, it can be added in the case. But usually the person who files the case, right, his name will be there. Right? There is one called MC Mehta. He files a lot of cases relating to environmental matters. So if you open any environmental law book, you will see tons of cases, MC Mehta versus Union of India, because these are public interest litigations. But along with MC Mehta, there may be other people as well, okay, who are added. Next is lack of political willpower. The formation of adequate law and their implementation are not willfully desired by political representative, which is also causing restraint in development of law of tort. Government is not effective as it ought to be in reference to law and justice. So when we talk about law of torts, okay, even though we have cases wherein it is being developed, there are certain legislations also. Okay, there are certain legislations like we have Motor Vehicles Act, we have Consumer Protection Act. Like that, there are some laws. So if government tries to bring more legislations, this like branch of law would have developed much faster, because we don't have such legislations, a lot of such legislations. That has also contributed in slow progress. Expensive and delaying judicial system. Again, once a case is being filed, it takes a lot of time to give a decision. That is also one of the reasons why people do not prefer going to the court, or might be in between, they prefer to withdraw the case rather than wasting their time so many years in one single matter. Okay, so there are these two cases, MC Mehta, like I mentioned, MC Mehta, right? He files a lot of public interest litigation. So this is also one of such cases, MC Mehta versus Union of India. Justice Vagbati said that we have to develop new theories and create new norms that will adequately deal with new problems arising in a highly industrialized economy. We cannot allow our judicial thinking to be constructed in terms of the law as it was prevalent in England or in any other country for that matter. We are of course ready to receive light from any source, but we have to create our own jurisprudence. It is fine that we are getting the ideas or we are deriving the concepts from England, but it should not happen that we simply rely on that. With time, we need to come up with new processes, new theories, new doctrines as well. Okay, because time demands for that. And like that, only Supreme Court had developed this concept of absolute liability, that whatever principle was applicable, it was good, but it was not serving the purpose because we live in an industrialized economy. So like that, it will develop with time, which time we should come up with new principles. It is pertinent to mention here that Section 9 of CPC, as amended, empowers civil courts of the country to try all kinds of suits which are civil in nature. So whatever matter comes before the court should take up the matter, and court should try to see what all like principles or whatever doctrines we need to develop in order to address that particular problem. And that's how these concepts would develop properly and faster. Okay, another one we have Jai Lakshmi Salt Works versus State of Gujarat. The entire law of torts is morally based and construed. Therefore, it would be primitive to strictly shut down or eventually to ever expanding horizon of tortious liability. Even for social development, orderly development of the society, what happens is that liberal approach of fraudulent liability of the court would be favorable. So when we talk about law of torts, okay, it is what? It is nothing but morally based and construed. What is right and what is wrong, based on that these concepts have developed. Okay, that it is not right that we are interfering in someone else's private property. From there, a certain concept has developed. It is not right that we are affecting someone else's private right to enjoy a plot of land. From there, another concept developed, nuisance. So like that, different concepts would develop, and we should try to see how, based on Indian situation and the society and the customs that apply in India, we need to see how we can develop these new concepts. So it is very much important that in India we have a different, or we try to codify the laws as much as we can. Okay, so when we talk about codification of laws, even though law of tort is considered to be uncodified, there are certain legislations. So these are some examples wherein some provisions or the other relating to torts are mentioned. Okay, like Judicial Officers Protection Act, Indian Carriers Act, Cattle Trespass Act, Easement Act, Workmen Compensation Act, War Injury Compensation Act. All these compensation matters also would fall under torts only, right? In a certain industry or factory, if a workman suffers injury or accident, he or she is entitled to compensation. So those would be covered. Fatal accident, Trade and Merchandise Act, Specific Relief Act. This legislation provides for different types of reliefs that we can claim, whatever might be the matter. Okay, so like that, we have a lot of different things, and these are also the two legislations which are even included in your syllabus. Okay, so even though we say it is uncodified, we do have few legislations wherein we see some or the other provision relating to torts. So law of torts is based on English common law, and it has contributed. English common law has contributed a lot in terms of development of tort in India, and in terms of providing relief to the victims, whoever decide to approach the court. To constitute tort, act or omission from the defendant is required, and it must cause legal damage and legal remedy as well. So when can we approach the court? These are actually the three elements that we will discuss later. That there is some act or omission. A person has done something or he has failed to do something, and there is legal damage. I have suffered loss, I have suffered damage, then only I can seek a remedy from the court. I can go to the court and file a case seeking for remedy. Okay, so this is how law of torts has developed in India. And it is still something which is like still developing, that right? We see amendments being made in the existing legislations. In 2018 or 19 itself, we saw major amendments being made in Motor Vehicles Act. In Consumer Protection Act also some changes were made in 2019. So these are nothing but with time, we try to make the necessary changes so that law is like something which suits the need of present society. So like that, it has gradually developed in India. Is this part clear?
Yes.
Okay, slow.
Maybe exam point of view, the question what we can expect from this topic is origin of tort in India, something like that, is it?
Yeah, origin of tort you can expect. Then what is tort? What are the elements of tort? There is one concept called iube jus ibi remedium. Actually, these questions are from previous year question paper only. Okay, so like that you can expect.
Okay.
Then there are these principles as well, damnum sine injuria, injuria sine damnum. These are again very important. Almost
Those
every
you would have covered in your previous class, or you are going to cover in next
no,
class?
these I'm going to cover. Only some parts I
Okay.
have covered, like differences between tort and crime, tort and contract, like that I have covered. Okay. Okay, fine then. So we'll continue tomorrow. 8 o'clock is 7 o'clock. Is it fine?
For me, it's fine.